Thanks to Sone Prakashan for inviting me to have a dialogue with you on electronic evidence, the subject. Before I proceed to this subject, I would like to introduce myself because I am not a very famous personality, but I may tell that I am ex-district judge. I have written books on about 7 to 8 subjects. Out of them, prominent are the Basic Law of Evidence, the second edition of which was published in the last year, received overwhelming response. The other book I must refer is on a difficult subject of execution of decrees, running in about 800 pages, was published in 2018. Recently, my other book, which is awaiting publication, is on Commercial Courts Act, and also for the budding lawyers, a revision on Criminal Procedure Code. I am also associated with ATC, that is Advocate Training Course, which is run by Sone Prakashan, the information about which you will get in the strips below this video. Now, averting to the subject, electronic evidence. First, I will state what is electronic record, because what is to be proved is electronic record. The term electronic evidence, you will not find it in any book, in any codified law as such. What is proved before the court, what is to be proved before the court is electronic record and not the electronic evidence. Electronic record, if to be stated in simple language, it means all the data in different electronic devices, including the computers, laptops or video cameras, mobiles, and everywhere, digital cameras. All this is called as electronic record. There is no definition of electronic record in Evidence Act. All the definitions pertaining to the electronic record, such as digital signature, electronic signature, certificate, etc., all these definitions are borrowed in Evidence Act. In the last clause of Subsection 3, which defines electronic record and everything. So, further I would like to state that how this electronic record is created. Though I am not a computer expert, probably many of us know that electronic record is created in these computers with the help of computer languages. The main computer language is binary code, which contains only 2 alphabets, that is 1 and 0, that is binary code. Bi means 2. These 1 and 0s are used for creating record. Everything which is fed to computer is in fact fed in this binary code that is processed with the help of software programs, and then we see it on computer screen. So even if you feed A to computer, A must be like 110. If it is A and we feed 110, that is processed in CPU, and then A appears on your screen. This is the way in which this computer electronic record is created. In fact, that is the primary evidence, but thereafter that conversion is also stated as primary record, a primary evidence. Now, we must remember one more thing here. Then when you have an access to internet, the record created by you is never vanishing. It permanently remains there. Even if you delete, your footprints are always footprints of that electronic record. It is in electronic science called as footprints. Those footprints are always left in the electronic record with you. The Google is always observing you. So this is unvanishing record. And I will also like to state something about metadata. Metadata means the detailed information of the electronic record. For example, pause for a minute. Metadata means the details of the record that is created. For example, I will show you this photograph. This is a photograph taken by me on my computer. When this photograph is taken, who took it, by which instrument it is taken, what is the information about the lens, who owned this instrument, everything is available in this record. You can see it. This will give the information about the details. It shows the details when I took this photograph. This photograph is taken on 27th June 2015 by, I changed the mobile thereafter, therefore it is not giving the information about the, but SD card, DCIM camera, it was taken, and date is also given, every detail. Even it gives the location from where this photograph was taken. That is the value of original record of this photograph. It gives every information, it gives even location. Similarly, the record of files created on computer, even if you change it, you can get when it was changed, how it was changed, what was the original, what was deleted, every such information you can collect about the computers. This is some information about the metadata. Now we will go over to again the subject. Before going to that subject, I would like to state the definition of the word document. This definition of the word document is not referring to electronic record in Evidence Act, because all the evidence that you have to give, you will have to give it as per the provisions of Evidence Act. The document is defined in section 3 and the definition reads like this. Document means any matter expressed or described upon any substance by means of letters, figures or marks, or any more than one of these means intended to be used or which may be used for the purpose of recording that matter. So this definition is not giving any reference of the electronic record. But the word evidence is also defined and that gives reference to the electronic record. The word evidence is defined in Evidence Act section 3, which says that evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to the matters of fact under inquiry Such statements are called as oral evidence. Evidence can be only of two kinds. Because courts are human beings, they can receive your evidence or perceive your evidence only in two ways. That is, it must be either oral or documentary. No third kind of evidence is given before the court. The third kind of evidence, which is called as real evidence, which is not defined in the Evidence Act, but you find a reference about it when I come to the latter portion. So, evidence means oral evidence and documentary evidence. The oral evidence is referred in clause 1, which I read just now, and now I'll come to the definition of documentary evidence, which states that all documents, including electronic records, produced for the inspection of the court. Such documents are called as documentary evidence. Thus, the word evidence has a reference of electronic record. And this electronic record falls within the definition of the document. So what is to be proved before the court is the document containing electronic record. Basically, a document is to be proved before the court. Usually, apart from that electronic record, usual documents we prove before the court. In what manner they are proved? They are proved with the help of all the provisions about documentary evidence in Evidence Act are from section 61 to section 100. Important there are of the beginning 6 sections we will be referring. That is section 61 to 67. Section 61 says that documents may be proved either by primary evidence or by secondary evidence. The question arises, what is primary evidence? That is defined in section 62. What can be primary evidence? What is secondary evidence? That is defined in section 63. And then section 64 says that for proving documentary evidence, you must produce original before the court, primary evidence, which is original. Primary evidence you must produce before the court, and if you are unable to produce primary evidence, then secondary can be produced. Before reading section 64, I will like to read one clause of section 63, which defines secondary evidence, which runs like this. Section 63 defines secondary evidence like this. Secondary evidence means and includes 1. Certified copies given under the provisions hereinafter contained. Those provisions are from section 676 onwards, and they give presumption about to the copies. Those presumptions are stated in section 77 about the contents, etc. Thus, certified copies are secondary evidence, and the second clause is important for us, which I will read. Secondary evidence means and includes copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. Thus, copies made from the original by mechanical process. The printer gives us printout. That is a mechanical process, and that itself ensures the correctness or accuracy of the copy, and therefore it is a secondary evidence if we take out a printout. Then section 64. It says that the proof of documents by primary evidence, The documents must be proved by primary evidence except in cases hereinafter mentioned. So primary evidence is a primary requirement, and if that is not possible, then except in the cases hereinafter mentioned means mentioned in section 65 and 66. So primary evidence must be given before the court, and if not possible, then only secondary evidence can be given. In case of ordinary documents, what we do, for example, I want to produce a cell deed before the court. I produce the original cell deed before the court, and then I want to rely the court on it. So firstly, it must be proved that it is original cell deed. Then you will have to prove the contents therein. Contents means contents of document or proof of contents of documents or proof of documents is required to be proved according to section 67. It says if you want to prove the contents of document or if you want to prove a document, you will have to prove the handwriting and signature thereon. This will prove the contents of document, and then court will take that document on record for reading in the evidence. A simple example thereof. Thus, for proving a document, according to section 67, one must prove the handwriting and signature on the document. Section 67 reads like this: proof of signature and handwriting of a person alleged to have signed or written the document produced. The section says like this: if a document is alleged to be signed or to have been written wholly or in part of any person, the signature or the handwriting of so much of such document as is alleged to be in that person's handwriting must be proved to be in his handwriting. So proof of document means proof of handwriting and signature. If the document is handwritten and signed, it should be produced and proved. Take again example of the sale deed. If I want to rely on that sale deed, I must produce the original before the court. I must prove that it is original. Then I must prove that it is in the handwriting of particular person and is signed by that particular person. The manner of proving handwriting and signatures are stated. There are 5 different ways recognized by the Supreme Court, and 9 are stated in a ruling reported in AR 1957, Manipur, page 9. Thus, proving of handwriting and signature proves the document. But remember, proof of document and proof of truth of the contents of document are 2 different things. For example, as usually I give the same example. Suppose I wrote a letter to my friend that on 1st January 2020 I met Prime Minister Mrs. Indira Gandhi and she donated rupees 5 lakhs to my institution of blinds. Can I write such letter? Yes. I wrote such letter to my friend with my signature. Somehow that letter came before the court. Now prove that letter. That is a document. So for proving handwriting and signature, I'll be called in the court. I'll be asked the questions. Mr. Wagh, whether this letter is written by you? Yes. Whether it is in your handwriting? Yes. Whether it bears your signature? Yes. This will prove the letter. It will be now read in evidence. But what about the contents of that letter? Contents of that letter, truth of the contents, whether some facts are written in that document that I met Mrs. Indira Gandhi on particular day, that she gave me 5 lakhs, that I have an institution of blinds. These facts are stated in the letter. Whether they are true? Absolutely false. So, contents of document and truth of the contents of document are two different things. Now come to the electronic record. This amendment of section 65A and 65B came in Evidence Act for the first time in the year 2000. Prior to that, there were electronic documents. How those were proved? With the help of section 61 to 65. So if at all a person was having the original with him, he was producing the original. If not, he was giving secondary evidence according to section 65, if primary is not available. This was the method followed previously. Now, amended provision also nowhere forbids this procedure. It is nowhere stated that electronic record cannot be proved with the help of section 61 to 65. If you want to prove the electronic record with the help of primary evidence, then you can give it. What is that primary evidence? That primary evidence is contained in the electronic device itself. So, if it is in mobile or if it is in your laptop or computer, desktop, you produce that is loaded in case of mobile, it is in the SIM card or in the memory card. In case of laptops or computers, it is in the hard disk. Even in CCTV, it is in the hard disk. Produce that original hard disk before the court. That will be a primary evidence. You can play that primary evidence before the court with the help of device. So that is the primary evidence that you have to give before the court. If that primary evidence is given before the court, question of going to 65A and 65B does not arise at all. Or even going to section 65 does not arise at all. So primary evidence of that electronic record can be given by producing the original record. That means the device which contains that electronic record. If that is produced, then you will have to give evidence. You will have to prove before the court that it is original device. That will be proof of that document, and then prove the truth of the contents appearing therein. If you have videographed something, produce your mobile. If it is videographed on your mobile or camera, digital camera, produce the camera before the court or produce the mobile before the court, play it. And then you will have to prove the truth of the content, means prove who is appearing on that video, what is the place, whether you know about it, what are the persons, how you know them, what happened. You just have to give evidence about it. On what day it happened, on what day it is recorded, and that it is original. You can, for proving that it is original, you can use metadata, as earlier stated, or that AP or IP given on that. Every instrument has got that ownership record. So that will prove that it is original. Then prove the contents thereof. Now we will come to the much debated section 65A and 65B. Before that, I will also like to state about the video, which video means, what is video? Video is a group of photographs. there are catena of decisions saying that one single photograph is a document. And this video is nothing but group of photographs run one after the another. The film, if you take the film, it is if you run it, you get the video. Why? The science behind it is that persistence of vision. That means any image, if you see that, it is retained on your retina of eye for 1/16th seconds, and immediately thereafter, if another further picture appears, continuously within that fraction of seconds, you get the effect of moving picture. You probably might be knowing, in childhood we were drawing on a cardboard. We used to draw a cage of parrot on one side, empty cage, and parrot on the other side of that picture. And if you revolve that picture, you can see that the parrot is in the cage. Why it is? Because of persistence of vision. That is the science behind it. So video is a group of photographs. Naturally will be admissible in evidence. Come to section 65A and 65B. I again say that section 61 to 65 can be used for giving electronic evidence either by primary or secondary. Section 65A and 65B are special provisions in respect of secondary evidence of electronic record. Though this is a special provision, it nowhere bars the original provisions of section 63 and 65. I'll read section 65A. Section 65A, title Special Provisions as to Evidence Relating to Electronic Record. The section says, the contents of electronic records may be proved in accordance with provisions of section 65B. The word is may be proved in accordance with. The word may gives discretion to a party to prove it. Word may say means it says that you prove it either as per provisions of section 65B or in any other manner you like, which is permissible under the law. So this section 65B is one of the way in giving secondary evidence. Before starting reading this section 65B, I say that up till now, till today, I have not come across any authority of the Supreme Court or of any High Court which analyzes this section 65B. You will come to know why it is not analyzed when I will start reading it. Section 65B, subsection admissibility of electronic records. It reflects only to admissibility of electronic records. It says that notwithstanding anything contained in this act, whatever may be the provisions in this act, any information in electronic record which is printed on paper, stored or recorded or copied in optical or magnetic media produced by a computer Magnetic media means on pen drive or compact disc, that is CD. If it is printed on paper or copied on this magnetic media, hereinafter referred to as computer output, it shall be deemed to be also a document. So this printout on paper or on any magnetic media will be deemed to be a document. It nowhere says that it will be original document. This copy or printout will be deemed to be a document. When it will be deemed to be a document if the conditions mentioned in this section are satisfied. If the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof of the production of original as evidence of any contents of original or of any fact stated therein of which the direct evidence would be admissible. So this printout will be admissible in evidence if it satisfies the provisions of this section in relation to two things. One, the conditions in respect of computer also must be satisfied, and condition in respect of the information also must be satisfied as mentioned in this section. What are those conditions? Those are stated in subsection 2. The subsection 2 reads like this: the conditions referred to in subsection 1 in respect of a computer output shall be following. What are those conditions? Those will be following. Those are given in A, B, C and D. If these four conditions are satisfied, then only this computer output will be admissible in evidence and it will be called as document. Otherwise not, if you want to give evidence according to section 65B. What is the first condition that is stated in clause A? It says the computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purposes of any activities regularly carried on over that period by the person having lawful control over the use of the computer. Here I would like to explain the section processed. Process means the computer is, as I have already stated, the computer is given the feeding in computer language, may it be binary code or recently developed languages of the computer, that is C++, C, then Java, etc. In those languages, computer information is fed to computer, it is processed. This process may be of conversion of this information into visible information, or it may be a process like used in computers in banks by software. In banks, if a particular amount is inserted in account in the computer, it is processed. It immediately on that amount, the period, if the amount is given and period is given, it calculates interest for every day, every year, etc. It automatically goes in several registers of accounts mentioned in the messages thereof also are automatically sent. This is the process that is done on that entry. So in words used, the computer was used regularly to store or process information for the purposes of any activity, regular activity. What this subsection requires: one, that the computer was regularly used over the period over which the computer was used regularly to store the process. Means the electronic record, this computer was regularly used for feeding the similar kind of information. Even clause B at this juncture can be read, during the said period, information of the kind contained in the electronic record of or of the kind from which the information to so contained is derived was regularly fed into the computer in the ordinary course of said activities. So your computer was proper. It was regularly used to feed the information of the kind which appears in the electronic record. If I am going by a bus or car, or I am moving on the road, I see a particular incident. I just videographed in that incident in my mobile. Was my mobile used for regular such activities? No. It was not used for those regular activities. So this electronic record will not satisfy this condition. Suppose tomorrow a friend comes to me when I am working in my office, he wanted to send some message or email to somebody. He uses my computer and sends that message. Whether the printout of that message taken from his computer will be admissible under this section? No, because the computer used by him was not in his lawful control, not under his lawful control. Because subsection 1 requires that over the period by the person having lawful control over the use of the computer. So if my friend uses my computer, the email sent by him or printout thereof will not be admissible under this section itself, because it is not satisfying this condition. If I want to send some message and I go to cyber cafe and send message, that message copy thereof will not be admissible in evidence. I also cannot produce. I was not having even lawful control over that computer. So it is very difficult to satisfy these conditions for this under section 65B. Secondly, second provision, B clause I already read, that it must be fed into the computer in ordinary course of said activities. Regular ordinary activities. Subsection C, it is proper and it says that throughout the material part of the said period, the computer was working properly and in the meantime it was not affected. If at all it was affected by any virus or other things, then that affecting of virus has not affected the record in the electronic record in the computer. That is the requirement of clause C. And clause D says that the information contained in the electronic record produced or is derived from such information fed to the computer in the ordinary course of the said activities. Again, a similar requirement. Ordinarily, this computer was used for that purpose. So it is rather very difficult to comply these provisions. In Bankers Books Evidence Act, a similar provision is made in respect of the electronic record. Under section 3 of the said act, the certificate issued by the banker is presumed to be true and correct. And a similar provision has been made, but rather it is a better provision than this, under which the secondary evidence is admissible. Subsection 3 is about the computers in one lane or several computers are used at a time and all the information is always given to all such computers in lane. Then it will be treated as one computer, not very much important. I will now come to the certificate which is to be issued under subsection 4 of section 65B. A very, very, very debated question. It has been also ruled by the Supreme Court and other courts. I am not having that authority to criticize any ruling on this point, but I am expressing my view on this point. Let us read section 65B4. What it says. It is about the certificate to be given for the proof of this computer output for making it admissible in evidence. The wording of this section. Subsection 4. In any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, any of the following things. There are A, B, C, 3 things. A certificate about any of one of these things will suffice the purpose according to the wording of this section. Further, will it be sufficient? Give a second thought. Will it be sufficient? What is the requirement of subsection 4? It says that in any that is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, A, identifying the electronic record containing the statement and describing the manner in which it was produced. Just identify, that will suffice. That this is the original, taken from the original computer, and it is produced through printer or by giving a command, the manner in which it was obtained. Is it sufficient to prove that electronic record, this certificate? 1. This is clause A. Clause B says, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. Means giving of the particulars of that device, that my laptop was of this much memory, its hash value was this, the IP was this, etc. A certificate to that effect. Need not state anything about the contents of electronic record. A certificate to this effect, will it satisfy the requirement of the court? This is second clause. If this only this certificate will suffice, it will be a compliance of section 65B4. The third clause says, which is more important and complicated, it says that dealing with any of the matters to which the conditions mentioned in subsection 2 relate. So, any of the matters mentioned in subsection 2, I read A, B, C. That means a person having lawful control had paid to the computer and the computer was working properly, etc. If these conditions are to be stated in the certificate, these things are to be stated. Any of these things are to be stated in certificate because the wording is a certificate doing any of the following things. It further says that and purporting to be signed by the person occupying a responsible official position in relation to the operation of the relevant device. By whom the certificate is to be given? By the person who has lawful control and controls the operation of the computer. That person has to give certificate stating that the contents therein are true and correct. Take an example that I am a plaintiff, I am a shopkeeper, I sell the goods from my shop, I maintain the record of particular purchasers. A purchaser purchased several things from me but did not pay the purchase amount. Therefore, I want to file a suit. So I will produce this computer output because I cannot produce the original computer before the court. I will pray to the court that I want to give evidence about under section 65B 4, section 65B. What I will do, I will take out a printout. I'll just give a certificate that I was maintaining everything therein as required by section 65B. That certificate by whom is to be issued? Naturally by me. I produce the certificate before the court. Has this certificate got any presumptive value about the truth of the contents therein? No. This certificate is not having any kind of presumption under any law for the time being in force. This certificate is, as it is not having any presumption, I will have to prove it before the court by coming into the court. I will have to step in the witness box and state on oath that this is a certificate issued given by me. It bears my signature and prove the truth of the contents therein. Means prove that the entries were made by me, everything was done by me. I sold the goods to a particular person, he did not pay. If I am bound to state that because this certificate is not going to help me. So if I am producing that certificate, I will have to give evidence about prove that document before the court, prove the truth of the contents therein, then only court will be in my favor, if my evidence appears reliable, of course. So what is the use of this certificate? Will this certificate satisfy the requirements of the word proved as defined in the Evidence Act? The definition of the word proved is very nice. The word proved in the law of 1872, which is not changed till today and cannot be probably changed. The definition says a fact is said to be proved when, after considering the matter before it, court either believes it to exist, means the word used is matter and not evidence. After considering the matter before it, the matter includes evidence as well as real evidence. Real evidence means inspection by the court, the weapons before the court, the demeanor or manner of the witnesses, their reliability, they are coming from rusticness of the women or literacy of the witness, etc. All these come within the matter. So definition says a fact is said to be proved when, after considering the matters before it, the court considers that it exists or considers its existence so probable that ordinary prudent person will act on the supposition that it exists. So if any ordinary person, by considering the matter before the court, will come to the conclusion that yes, the fact must have been in existence, then the court will conclude that it exists. So evidence is always to be looked from the eyes of a ordinary prudent person. If this certificate alone is produced before the court, it will not satisfy the conscience of the court. Court will require whether the contents therein are true and correct. That must be proved before the court. The evidence is to be given to satisfy the prudence of ordinary person. So certificate, any electronic record. The electronic record is one thing that it is easily available. It can be tampered very easily. A false record also can be prepared about it with such an advanced science of the electronics. Therefore, if such evidence is before the court has to see whether there are possibilities of its manipulation, whether there are possibilities of its tampering, and if court is fully satisfied that the evidence is not tampered, it is a video that has been played before the court. If oral evidence pertaining to that video is quite reliable about the place and identity of the persons, think like an ordinary person. Court must think like an ordinary person, may rely on that evidence. So evidence, whether it is reliable or not, that is to be viewed by the court like an ordinary person. So, this is the electronic evidence. In sum and substance, I say that it may be proved according to section 65A and 65B, but it also can be proved under section 61 to 65. I conclude with this short note on electronic evidence. I say, and it is my view, that section 65B is not happily worded. It is not a proper legislation. On the contrary, a better legislation can be found in the Bankers Books Evidence Act and also in Commercial Courts Act, where electronic record is to be adduced as evidence. Before concluding, I just forgot to mention that in a ruling reported in AIR 2018, Supreme Court, page 714, Shafi Muhammad versus State, it has been stated that the provisions of section 61 to 65 can be used for proving electronic evidence. It has been concluded in that ruling, and probably previous case laws are also discussed in that ruling. That ruling was pertaining to the persons who are not having that device, but in fact it is applicable to all civil records. And I will also like to talk as to why these acts and laws are not easily perceivable. The drafting of legislation which is borrowed from Anglo-Saxon system is very intricate. The use of the words ifs, buts, provisos, provisions, explanations, exceptions, etc. All these create a chaos, and the readers are repelled because of that. And therefore, whenever I have written my books, I always kept in my mind the principle and my object that simplification of law will ease the way to achieve the goal of justice. Therefore, my books are written in common parlance, and I again reiterate that they are not in that fashion of cut paste. The simplification of law will ease the way to achieve goal of justice. While writing my books, I have never used cut paste method, and it is always in simplest possible language. And I will also like to state here that my another book in similar manner is awaiting publication and will be published within about fortnight on the subject of Commercial Courts Act, a very nice law, despite some mistakes therein, but it is a very nice legislation to expedite the disposal of the cases. I have given notes on some incorrect provisions therein. So also the book on Criminal Procedure Code, a short book which is summary of Criminal Procedure Code. It is written only for the purpose for the budding lawyers and the students or the persons who are appearing for the examinations of judicial magistrate and civil judges. In that small book, I have simplified the provisions of CPC, and it can be very useful for revision on the subject. It is running hardly in 150 pages on Criminal Procedure Code. I again request you all, the listeners, if at all you will like this video and if you find it useful, please spread the contents thereof or spread the link thereof amongst all those who need it, because I think that it is useful for all advocates and also the honorable judges to think over their decisions in this line. And my book Basic Law of Evidence, written in very simple language, is also available to all. Very few copies of execution of decrees are remaining with the publisher, but Basic Law of Evidence can be had as it is published recently, and few more copies thereof are with me. And I will also like to book your orders on Commercial Courts Act and on the Criminal Procedure Code with Sone Prakashan, and the Advocate training course will be of great use to budding lawyers and the persons who are appearing for the course for the examinations of civil judges and junior division, because I am part and parcel of that course. Thanking you and close.
Subscription, sir.
So, like if more persons will subscribe this video, I'll be talking on different subjects, including Commercial Courts Act, execution of decrees and other laws and other subjects, legal subjects, in the same language, if I'll get more subscribers to this video. Thanking you all.
Hello friends, I am proprietor of Sone Prakashan. These are the recent books of Advocate S.S.Wagh published by me, namely Execution of Decrees, second edition of Basic Law of Evidence, and 6th edition of Nyaya Mandirat. Awaiting publications in the next month are Commercial Court Acts and Summary of Criminal Procedure Code. I also arrange lectures of Advocate S.S.Wagh on different law subjects. I am running the ATC, that's Advocate Training course. This course has proved to be very useful for budding lawyers and students, as well as to advocates who appear for examination of civil judges and judicial magistrates. This kind of training program is launched for the first time in India and received great and unpredictable response. Participants get practical experience of conducting civil and criminal cases with all details, right from drafting matters, roznamas, examination of witnesses, till arguments and writing of judgments. For any query, please contact given number on the screen. Thank you.